Okay, thank you and for joining the webinar. It will be a 30-minute look at how contractual provisions can be inserted in a contract in a way that your client might accept them. In an earlier program, Nahum Gabriel discussed two types of limitations of liability on a design firm, and the two he discussed, a limitation of liability and a waiver of consequential damages, are often the subject of extensive negotiation between clients and design firms. That is because in many cases, they are seen as an effort by the design firm to reduce its need to perform adequately. If a client has a lot at stake on putting the capital asset in place, the client might not want to even consider reducing how the client will be able to hold the design firm responsible. So complete waivers of consequential damages are difficult to negotiate with a sophisticated client, and all-encompassing limitations of liability can be difficult unless they have a high amount specified or result in a fee reduction. But over the many decades, standard contracts, those of the AIA and Engineers Joint Contract Documents Committee, have included more subtle limitations on the exposure of design firms, with language that has often been construed in courts as being able to provide the intended protections. Okay, first we'll look at what is in the standard contracts using the AIA B101 2017 edition as a model. It provides contractual limitations in a variety of ways, but of course, they are only effective between the parties to the contract. With the exception of one example, we do not have time today to address the next level of contractual protections, which are contractual indemnity obligations negotiated with the client that moves the target for claims from others, from you to your client, and often shifts your liability for harm caused to non-contractual third parties to your client. It will be included in part of the program where we look at your valid concerns about being held liable because of the effects of climate change. First, you need to know why contractual protections have been allowed to develop. In 1972, a local architect here in DC, Aaron Martirosyan, was working for the government to oversee the creation of the Union Station Visitor Center for the bicentennial. When the project slowed, he was requested to step in and replace the architect the Park Service had hired to undertake and Martirosyan was supposed to undertake additional design and construction coordination services that were necessary to complete the project by July 4th, 1976. At that time, Standard 9 of the AIA Code of Ethics stated, an architect shall not attempt to obtain, offer to undertake, or accept a commission for which the architect knows another legally qualified individual or firm has been selected or employed until the architect has evidence that the latter's agreement has been terminated and the architect gives the latter written notice that the architect is doing so. Now, Mr. Martirosyan had been acting in an advisory capacity on this project under contract with the National Park Service, and in such capacity had full knowledge of the status of the architect's contract. So when they hired him, the AIA suspended him from membership. In 1977, he filed an antitrust challenge to the ethical canons of the AIA, seeking the standard treble damages against both the AIA, which found him guilty of actually violating two of its ethical standards, and Seymour Auerbach, the architect who filed the charges of ethical misconduct with the AIA. Judge John Sirica, you might remember him from Watergate fame, ruled against the AIA, and the AIA eventually settled the complaint for $700,000, which is about 3.5 million in today's dollars. But that was not the only challenge to ethical restraints on the professional practice of design firms. The National Society of Professional Engineers had a provision in its code that prohibited engineers from quoting prices before they were hired. NSPE attempted to justify the provision as within a rule of reason, designed to protect the public interest by keeping engineers from understating costs in a manner that might affect public safety. In NSP versus the United States the US Supreme Court upheld a lower court decision that nullified the provisions in the canon of ethics as a violation of the Sherman Antitrust Act. In his opinion for the majority in that case, John Paul Stevens reviewed antitrust precedents, including how the court earlier had interpreted a law in a case that ruled that attorneys could advertise to distinguish regulation of professions from ordinary businesses. The court had never interpreted the law to prohibit every contract that restrains trade, but had interpreted flexibly to prohibit acts that were unreasonably restrictive of competitive conditions. Stevens noted that although the statement within the canon of ethics was not price fixing, that no elaborate industry analysis is required to demonstrate the anti-competitive nature of the agreement. It basically operates as an absolute ban on competitive bidding. That is what Stevens wrote. And the district court was empowered to fashion appropriate restraints on the society's future activities to both avoid a recurrence of the violation and eliminate its consequences. So all professions were seen as both professions and businesses, and the professional interests were not allowed to prevent business competition. So after that, design firms could advertise, competitively bid for contracts, and limit their liability in the same way that other businesses were doing. But there was one condition: public policy prohibits the shifting of harm caused by the sole negligence of the design firm, except through the purchase of insurance. Nahom looked at the language of Exhibit 1 of the EJCDC E500 that has limitation of liability options, and at AIA's B503 2017 version that discuss efforts to limit liability. And they are great ways to do that if you can negotiate them in a way that meets applicable law and that survives other provisions of a contract. But today we are going to look at less dramatic, but perhaps more productive ways to limit liability as part of the contract language. I refer to it as a holistic method of limiting liability. Here are some of the provisions in the AIA B101 2017 that protect the architect. And there are more. These have been added, enhanced, refined, and extended over the decades. So we will look at these in more detail. The goal is that you can use the AIA contract or the equivalent EJCDC contract, or add provisions to your own contracts, or compare what you get from a client to the standard language to protect your firm. This statement of the standard of care incorporates the language that every state uses as part of its jury instruction to determine if a design firm is negligent, and because of that negligence, liable to a plaintiff. In some cases, firms like to further qualify this standard of care by including language such as "and limited to" after "consistent with," or with an affirmative disclaimer of warranties, but neither is necessary. But you probably know that some clients want you to be the best or perform at the highest level, or otherwise set you up with an unmeasurable standard of care. That needs to be avoided. And you also need to never let the puffery that's in your advertising material get into the definition of the standard of care in your contract. Note that this provision also has language on the timing of the services. There's no guarantee of timely performance. And one argument is that a licensed design professional has to protect public safety by not forcing performance to an unreasonable schedule. And also be aware that this language protected firms during the COVID-19 situation because it really acts as a force majeure provision. There's no other such provision in an AIA contract. So delays caused by COVID restrictions were seen as excusable. Now, look at this highlighted sentence. Some owners' contracts state that the design firm cannot rely on anything provided to it and must verify information. Obviously, to do so is both a huge increase in services and exposure. And if you are working with client-provided consultants, you have no control over them. So by stating that you have the right to rely on them reduces your exposure if their information is wrong or their service is incomplete or negligently performed. So it's important to have this reliance language in your contract. In this one, the first highlighted provision establishes the architect as having a limited form of agency on behalf of the client. Being an agent of the project owner means that the contractor and the contractor's employees have no or very limited rights against the design firm. The action has to be brought against the owner since the owner is responsible for the acts of its agents. The disclaimer language for site safety, the safety precautions and program language, actually was added in the early 1960s in the AIA documents, mostly on the advice of Vic Schinner, the founder of our program. He was the insurance counsel for the AIA documents committee at that time. It is of critical importance, and many court cases have exonerated architects, or in the case of EJCDC language, engineers, in worker or bystander injury claim situations because of this disclaimer. And note, if the contractor is working under the AIA 8201 set of general conditions, the owner supposedly had the contractor both add the architect as an additional insured on the contractor's CGL policy and indemnify the architect for harm caused by the contractor's negligence. So that language in A101, 2007, in the insurance exhibit, for instance, for the additional insured status, can be very helpful to protecting the architect from bodily injury claims from workers or from third parties. Oop, there we go. What you do on a construction site is important to your client, but how you state what you do will be critical in protecting your firm. In the 1960s, the architect's contractual commitment was to supervise the work of the contractor. That was changed, and Vic Schinner had a role in that change because supervision was never what an architect did. So observe was used and then later changed to evaluate. In 1996, the AIA actually considered going back to supervision as part of a marketing effort, but case law showed the problem. So it was evaluate was put into the contract. You can always do something else: monitor, assess, examine, and even inspect if those are defined in a reasonable manner and if you are paid at a higher level of service. But if that's not the case, this language is effective in limiting your liability for on-site services. Note that authority implies responsibility, but does not require, in this case, an absolute rejection. The language on good faith was added in 2007 to further protect the architect. It means that the contractor and others cannot later state detrimental reliance on the architect's action and therefore bring a lawsuit against the architect when the architect took action to either test or not test. Architects really have three roles on most projects traditionally. The architect is a consultant during the design, making recommendations to the client, and the client accepts those recommendations in the final design of the project. The architect is an agent of the client during the construction phase services. But the architect steps out of the role of working on behalf of the client when the effort is to endeavor to secure faithful performance by the parties. So courts have given architects a qualified privilege, a quasi-judicial immunity, when they perform this role of providing interpretations and decisions. This language is meant to keep the project moving, and the architect is given protection for acting in good faith. A service that can lead to significant claims is processing applications for payment. It is an important duty and one for which the professional should receive appropriate compensation. So language such as this is vital to protect the architect from claims by the owner, the contractor, the lender, and others. Some project owners really want the architect to perform services during the construction phase as having a fiduciary duty, much like an investment advisor, an attorney, or an insurance agent, to put the financial interests of the client above all else. But even the service that an architect does in evaluating payment requests does not rise to the level of serving as a fiduciary. And note the 4 qualifications. The first is often looked at by project owners as an unnecessary protection for the architect. But it was added not to protect the architect, but rather to protect the project owner. It means that even if the client has paid the contractor, that money is not the contractor's until after substantial completion. It can be clawed back by the client if at substantial completion it is clear that the contract documents had not been met. The review of shop drawings can be a minefield for design professionals. Experience shows that it can lead to a number of claims, even though contractors would like shop drawings to be considered contract documents, and they are considered so in the consensus document system of agreements. Shop drawings are really meant only to be communication tools under the AIA and EJCDC contracting methods. So the highlighted provisions are valuable in limiting the liability of the reviewing design professional. Some owners want the review to ensure or guarantee conformance or otherwise elevate the shop drawing and submittal process beyond its intended reason for existence. This language means that the contractor has to meet the requirements of the contract documents, even if a required shop drawing was reviewed and approved. In 2007, in response to efforts by contractors to pad their revenues by submitting a massive number of requests for information as a way to show the documents were insufficient to allow construction as intended, this language was added. By requiring a special form that makes the contractor indicate exactly what information is needed and where the contractor looked to find the information, the design firm is protected from having to respond to unnecessary requests. You know, when the owner provides the contractor with construction documents, the owner is held to a warranty of their adequacy under the Spearman Doctrine, which was a concept created over a century ago by the Supreme Court. The contractor floods the design firm with RFIs to indicate that the design firm was negligent in its preparation of the documents, thus causing the owner to breach its warranty. As you probably have experienced, the contractor sues the owner for an increase in the contract sum and contract time, and that usually results in a negligence claim from the owner against your design firm. There are, of course, times when the contractor does need additional information. So having in place a system that allows that but holds back the flood of unnecessary requests is critical to protect the firm from claim situations. Few clients think design firms actually understand the owner's concern over the cost of the work. Those owners should hire a separate cost estimating service that works with the design team through the design process. But when owners rely on the design team, there should be language such as this in the contract. And now with inflation, material shortages, and supply chain disruptions, estimating the cost of work is challenging and a source of disputes. And because the cost of work is so difficult to estimate, the AI always had language on the reperformance of services. Prior to the 2007 AIA contract, if the owner established a fixed limit of construction costs and the bids came in over that, the architect had to redesign to reduce the cost. In 2007, every estimate was treated as a fixed limit, and architects found themselves redesigning routinely, which destroyed their profits. So in 2017, the language was changed so the architect would be paid for redesigning unless the architect could have reasonably anticipated that bids would be high. And everyone knows that construction costs are soaring, so architects using the B101 will end up redesigning for no fee or fighting with the client about this obligation. But the important language is that last sentence. It means that when the architect redesigned the project, the owner cannot later sue the architect for delaying the project and for damages such as increased lost profits, ever increasing construction costs, and other effects that they have caused. Nahom mentioned the waiver of consequential damages. The mutual waiver of consequential damages was added to the AIA design contracts, mostly because a similar waiver was added to the owner-contractor agreement. It was really slipped into the AIA design documents as a limitation of liability. But while owners and contractors can both experience significant consequential damages, and therefore a mutual waiver made business sense, design firms rarely have a situation where they can claim consequential damages against the client, while clients face situations where they have significant consequential damages because of delays that might be caused by the design firm. So this simple language is very protective of the design firm and really is a one-way protection. Knowledgeable owners either eliminate it or qualify it in a way that strips it of its value for the design firm. But as Nahom said in the earlier program, it is a valuable protection for design firms. Certifications can be a minefield unless the certification is limited to what the design professional knows as a fact related to the services provided, or can express a professional opinion based on the information available because of the services. This provision has been expanded in each edition, first by adding the that are consistent with this agreement language, and more recently with the absolute prohibition on any certificates or consents that would require knowledge, services, or responsibilities beyond the scope of the agreement. Part of the reasoning for this is that a broader certification would violate registration laws that require a design professional to only provide services within the professional's competency. So limiting certifications is extremely valuable, and that last line should be in every contract. Now, we're going to look at some limitation of liability options, and we'll use climate change exposures as an example. And these are the ones we're going to look at. Informed consent. I think the advice that they need to ask clients about specific resiliency concerns. You know, what parameters considered during the design, what investments will the client make to increase resiliency? And firms often use a checklist of questions that are project specific, geographically specific, and identified as to known conditions or anticipated changes to the climate. And once they do that, they ask their clients to sign an informed consent statement such as this. Informed consent can be used in situations other than addressing or not addressing climate issues. So consider using a similar informed consent provision for other situations, because that will be able to document that the client understood its risks. Now, disclaimers can be used, but remember, you really cannot disclaim all responsibility for harm you caused by your negligently performed professional services. A disclaimer such as this is useful to both inform your client and document the limit of the services the client wants you to perform. And a waiver of rights is an affirmative statement that a party, in this case a client, will not bring a claim. For climate change exposures, it is important that waivers can be used in other situations where the client knowingly, contractually gives up a right to act in the future. And this is the only contractual indemnity obligation we will look at. An hour could be spent on reciprocal indemnity obligations or indemnification of the design team for specific perils. But let's look at this in terms of the difficulty of designing in a changing climate. Remember that such obligations are only as good as the assets behind them. So if your client is a government agency, it probably is prohibited from defending and indemnifying a private entity because doing so would surrender sovereign immunity that the government client has. And if your client is something like an LLC or even a corporation, it might not exist when a demand for defense and indemnity is made. So they can have limited value to you. And we will finish with this. Standard contracts state that there are no third-party beneficiaries, but clients often want the lender or others to have the right to enforce the contract against the design professional. So holding on to the no third-party beneficiaries standard is a valuable way of limiting exposure. Even with this prohibition, a design firm can be the target of non-contractual parties who can argue detrimental reliance on the services provided by the design firm. So let's give you these 4 thoughts. You can negotiate a broad limitation of liability in your contracts, but often they will not work to completely limit your risk. You might have personal liability even if your firm has a limitation on its exposures, or your client may have narrowed the limitation of liability so it sounds good, but does not work as you might think. So use the standard contracts as references. EJCDC lets you use its language with impunity. And while the AIA documents themselves as a major profit center for the organization, much of the language in the AIA documents can be used as a model in your own contract. With the help of your legal advisor, parse out what changes to the standard language means. And because you realize that one slight change could strip you of protection or make you liable in a situation where otherwise you thought you would not be liable. And remember, while we would like you to use protected language as much as possible, your best risk management procedure is to only work for reasonable clients, perform your service carefully, document everything you do appropriately, and communicate with your client consistently. And that's probably the best risk management tool you have as your prudent practice. But look at these contractual provisions, see how they fit into your contract.